Fantastic. Carl, over to you.
Hello.
Sorry, Belinda.
No problem.
Good morning, everyone. I hope you're all doing well, and thank you so much for tuning into our webinar this morning. Just a few quick announcements before we start. This webinar is being recorded, and it's going to be published on our YouTube channel and website. So please remember to like and subscribe to us. And then if you haven't already, please do subscribe to our newsletter. This way you can keep in touch with the TVDM consultants team. Then TVDM Table Talks live discussion will also be happening next week, Friday at 9 a.m. This is a great opportunity to ask our consultants any community-related questions you may have. And then if you're in Cape Town, please join us for the upcoming Basket Physical event at the Lagoon Beach Hotel on 10th of September at 8:30 a.m. Then we're also very excited to announce that we will be hosting an internal dispute resolution event on the 11th of September in Cape Town. So please keep a lookout on our social media as more information on that will be released soon. And that's all the announcements I have for today. So for those of you that did not join when Anthony last co-hosted a webinar with us, I'm going to hand over to Razine to reintroduce him. Thanks very much.
Good morning, everyone. So Anthony is a director at Maurice Phillips Wisenberg, having joined the firm in 2000. He's an arbitrator and a fellow member of the Association of Arbitrators of South Africa. He specializes in dispute resolution, whether it's through the courts or alternative dispute resolution, such as arbitration, adjudication, and mediation, and predominantly in the field of construction, commercial, and property-related issues, amongst others being construction law disputes, covering a range of disputes between developers, contractors, subcontractors, architects, and other professionals, as well as sectional title and homeowners association disputes, which have been countless, in fact. He also attends to heritage-related disputes in terms of the National Heritage Resources Act, and until 2021, Anthony was a member of the Ministerial Appeal Tribunal, the Ministry of Cultural Affairs and Sport, the Western Cape government dealing with appeals from Heritage Western Cape. Also attends to disputes arising from the housing, as well as disputes relating to unauthorized building work, land use departure applications, servitudes, removal of title deed restrictions, and rights of ways planning and approval. Anthony also deals with disputes arising from lease, sale, or development of properties, both residential and commercial, as well as commercial matters which cover a wide range of matters, including drafting of agreements and general litigation in relation to a variety of disputes. So suffice to say, we are very lucky to have Anthony this morning.
Fantastic. Thank you so much, Carl and Razine. For those of you that did not catch it, just a reminder that we do have the Let's Get Physical event coming up in September. We have invited Antony to that as well. And we have got our internal dispute resolution workshop. It's going to be the very first and hopefully not last of its kind. And I think it fits in very nicely with what Antony does as an arbitrator. He is also a big proponent of internal dispute resolution when he doesn't have to litigate on matters, but I'm sure he'll tell you a little bit more about that. Antony, over to you.
Oh, thank you. Good morning, everybody. I'm going to try to be brief. I've got an hour, and the topic is pretty far wide-ranging, and it's quite difficult to try to capture that in an hour. So I'm just going to give a taste of how the courts have interpreted the obligations of an owner, both in a body corporate and in a homeowners association, how the courts have enforced the rules and the obligation to pay levies, and to what extent and what remedies either the body corporate has or a homeowners association has in the event that a owner doesn't comply with the rules or doesn't pay his levies, and to what extent, as I said in the blurb, the obligations are cast in stone. So the best way to kick off is the Mount Edgecombe matter, which I assume many of you are familiar with. And if not, I'll just give a reference. It was Mount Edgecombe Country Club Estate Management Association versus Singh. It's a Supreme Court of Appeal judgment which went a long way to sort of set the benchmark for how homeowners association rules are regarded and how they are enforced. This matter related to, well, there were a few issues, but the one that went to the Supreme Court of Appeal related to the rules relating to the road and whether the homeowners association was entitled to fine people for exceeding the speed limit, which was 40 kilometers an hour. Mr. Singh and her daughter were fined 3 times 1,500 Rand each, and they felt, no, well, one, they had excuses, and 2, they took issue with the imposition of the fines. They said they're public roads and a homeowners association can't take over the duty of the traffic authorities in imposing fines. So that went off. So they were challenging the validity of the rules, and that it went to the Natal High Court first time round, and the Natal High Court agreed and said, yes, you don't have authority. You're not the traffic authorities. You can't impose fines. That then went off to the Supreme Court of Appeal, and the court then looked at the nature of the arrangement between the homeowner and the homeowners association and found that it was based in contract. And I'll read from what the court said. And in many instances, I'm going to read from what the court says as opposed to trying to give a sort of summary of it, because they say it a lot better than I say it. And in this regard, they said that when the respondents, that's Mrs. Singh and her family, chose to purchase a property within their estate and became members of the association, they agreed to be bound by its rules. And there's the important part. The relationship between the association and the respondents is thus contractual in nature. The conduct rules and the restrictions imposed by them are private ones entered into voluntarily when an owner elects to buy property within their estate. By agreement, the owners of property within their estate acknowledge that they and their invitees, in other words, guests, are only entitled to use the roads laid within their estate subject to the conduct rules. And then said that any breach of the conduct rules was therefore breach of the contract entered into between the parties. And again emphasized that when you buy into a homeowners association, you enter into this contract voluntarily, and you are then liable for any breaches as laid down in that particular contract. So the court said that even if these were public roads, that made little or no difference. You've entered into an agreement, you agreed to abide by the conduct rules. One of the rules is you can't go more than 40 kilometers an hour. There's a fine imposed, and you're liable for that fine. So the court said there was nothing wrong with that rule. The fact that it was a public road or wasn't a public road was irrelevant. The homeowners association had authority over it, and you bound yourself to it. So the court then ordered that, or found that the rule was valid, unlike the Natal High Court, and found that it was therefore enforceable. In the judgment, the court referred to a matter of Bushwallow Park Homeowners Association and Fernandez, which sets out how, and that's a Gauteng High Court judgment of about 2015, which is quite illustrative of how the courts will interpret the rules. Now, in this instance, the trust, they bought into, it was a family trust, they bought into this homeowners association, and they decided they're going to paint their house with lime green stripes. Yeah. So, and the homeowners association saw what this house with the green lime stripes looked like, and they said, no, you've got to change that. We're not agreeing to it. They had made well, there was one step in between that. After they'd painted the building, they then applied for permission, or they then sent their plans, or not their plans, their paint colors, and the homeowners association said, not a chance. We're not agreeing to these colors, and asked them to change, and they said they're not going to do that. And this then went off to court for the court to determine whether or not the homeowners association were entitled to dictate what paint could be used, and whether they could tell them that they don't like the green lime stripes on the wall. So the court looked at the rules, and there was nothing specific in the rules which entitled the homeowners association to say what color it should be, and that could veto the color. But the court looked at the rules generally and could see from the rules there were architectural guidelines, there were rules relating to design and improvements which the homeowners had to agree upon specifications and materials. And then in relation to external finishes, the guideline simply says all external finishes and colors should be specified and color samples may be requested. That was it. They then said, see, there's nothing here which says we are required to get your permission. We must simply tell you what color we're going to use. And you can't hold us to whatever color you say is best, because it doesn't say anything along those lines. So the court then also said interpreted the rules with reference to the fact that it's a contract similar to what had been found, or exactly what had been found in the Edgecombe matter, and then applied the test or the formula for the interpretation of contracts as set out in the benchmark case of Natal Joint Municipal Pension Fund versus Indomani, a Supreme Court of Appeal judgment, which said how you go about interpreting statutes, contracts, and obviously then homeowners association rules. And the main aspect was that looking at it in context, in fact, I'll read just a bit what Indomani says, so we understand. In this case, and this is you'll come across this all the time when we're interpreting contracts, the courts will always refer to Indomani and how you go about it. And you don't just look at the words and try to see what the words say, because that's not sufficient. The courts held in the Indomani judgment and said that you firstly look at, there's three things you look at, not one, not two, but all three in together, and then you interpret the contract. And then obviously the rules, and said that whatever the nature of the document, consideration must be given to the language used in the light of the ordinary rules of grammar and syntax. That's number one, the language. Two, most importantly, the context in which the provision appears. And then thirdly, the apparent purpose for which it is directed. And that is now regarded as the trilogy of interpretation. And the overriding thing is it must have a sensible meaning, and that the courts can't redraft an agreement for the parties. You must look at those things and conclude the inevitable point of departure is the language of the provision itself, read in its context and having regard to the purpose of the provision. So having set out that benchmark, the court then looked at the rules and the context of estate, of living in an estate, and said, for example, there's no room to debate the contention that unit holders, let's say members, sacrifice a measure of freedom of choice about the nature of their homes or the use to which the house may be put pursuant to binding into an association. Typically, in such estates, developments, certain attributes are often chosen to characterize the estate. In some cases, rigid uniformity is organizing principle. In this case, uniformity was not the norm, but rather aesthetics were present in general terms, and a range of personal choices was allowed subject to a veto. So the court looked at that and then also dealt with certain other defenses that were raised. And they said, we didn't know that this rule applied, which you could dictate the color. And the court said that's not good enough. There's a duty on an owner to be aware of all the rules governing their estate. And if this rule says what the Homeowners Association says it means, that we can veto, then you're bound by it. The fact that you didn't know is not an excuse. And then they also said, and this is a theme which I'll come back to as we go in with other cases, they said the rule has been inconsistently applied, which is often a refrain. I'm sure all of you hear. They say, but why me? Look at my neighbor. Do you hear that often in homeowners disputes or sectional title disputes? They say, but why must I do this or not do that when Mr. Mrs. does exactly that? And the court said, an inconsistent application is not a factor that can upset the legitimacy or demand of the rule. So if the rule's valid, you can't say it hasn't been applied consistently, but we'll see to what extent that statement holds true in all respects. But generally, as a proposition, you can't say inconsistent, you cannot use inconsistency as a defense. Then the court, then they also argued, but there's nothing here which says what colors can be used, and therefore you can't stop us using lime green pinstripes. And the court said, no, that's not the point. The question is whether the Homeowners Association has authority to permit or forbid a color at their discretion. That's the question. If they can, then they can decide what you can or cannot use. And then they said, yeah, but there's nothing in the rule that says we can't use this. So how can you tell us we can't use it? There's no express rule. And the court said, well, it agreed that the rules were not set out very clearly. In fact, they used the word that the relevant rules may be accused of a measure of obliqueness. But in my view, a fair reading of the rules, and this is where the Indumeni comes in, a fair reading of the rules cited leaves no doubt that unit holders are obliged to get their paint colors vetted by the applicant. Second, the context of their estate. Remember what the Indumeni judgment, the context of the estate ideal determines how to read the text of the rules, the grammar. The system in the place, i.e. the system in place in the estate is one of control and oversight over improvements. And then went on to say, by entering into an estate, a homeowner cannot be encouraged, in its word, that there exists any freedom to do as it pleases with the exterior of the house. There's an overriding theme that houses must fit in and individual choices are fettered by this norm. So the court said that living in an estate creates what it used, restrictive, permeates the very concept of an estate. And therefore, by virtue of looking at all the rules and the obligation of a homeowner to submit plans, submit drawings, meant that you can't just do as you please. And therefore, in the context of the rules, the Homeowners Association was entitled to tell them to remove the paint, and the court agreed and ordered, gave it, well, they said it was specific performance, as in a contract where you don't perform, you get told to perform. The court ordered ordered them to remove the green paint and repaint it at their own cost. So that's an example of where the courts will lean over to try and interpret the rules for the purpose of which they intended, as opposed to looking purely at the grammar and saying, well, there's not a provision which says what colors you can use, and therefore you can do whatever you like. The courts will look at it with a far more open approach, as opposed to a narrow approach, as they were arguing. Another, there are many judgments which are quite relevant, and the one that comes up quite a bit is the deactivating of access controls, remote controls, biometric access, a whole lot of things to try force owners or to use it as leverage to compel an owner to pay their arrear levies, or due to the fact that they're not complying with the rules. And the courts dealt with that in two matters, which I want to highlight. There are probably many more, but the two which are sort of quoted quite often is the matter of Bull versus Waterfall Estate Homeowners Association, to 2020 judgment of the Gauteng High Court. And in that matter, the owner had fallen into arrears, and the access was, the biometric access was stopped, and they also, the Homeowners Association wouldn't allow the contractors who were building the house to access the estate. In fact, no, this wasn't a case of where they hadn't paid their arrear levies. It was where they were required to build within a certain time period, commence building within a certain time period, and then to complete within a certain time period, which is quite a standard clause in many many homeowners associations, and weren't interested in whatever excuses the homeowner gave. And he said, well, I was ready, but the plans were taking long at the council. There's nothing I could do, and you can't now deny me access or my contractors access. And most importantly, by doing what you've done, by deactivating me, you've spoliated, you've taken away my possession unlawfully, and brought an application, a spoliation application. Now, a spoliation application is when someone is in possession, peaceful possession of something, and that gets removed unlawfully. And the rationale for that rule is that it prevents self-help. So if I have an agreement that someone can use my car or my house, I rent my house, I can't then, because they breach the agreement, in other words, they don't bring the car back to me, or they don't pay their rent, that I can take away their possession. I can't go with my spare set of keys and take the car. I can't lock them out of their house. I have to follow due process. So they argued that by disconnecting the access, that was an incident of their possession, or it's called quasi-possession, and by disconnecting, they had been spoliated and brought this spoliation application. They never brought an application to set the rule aside, which we'll see happen in another judgment I'll get to now, but they said they had been spoliated. And the court then looked at that angle whether they had, and found that all the elements of spoliation were there, but the Homeowners Association said, yes, but it wasn't unlawful, because when you sign into the Homeowners Association, you sign the agreement, and the agreement or the rules say that the directors can do whatever they like to enforce compliance with the rules. And if there's a breach, we can impose fines, or we can take away the access. The rule didn't specifically say that, but they said it fell within their discretion to do what they needed to do to enforce compliance. And the court looked at that and said, no, that's amounting to self-help. So even if the agreement makes provision for it, you can't do it. You can't take the law into your own hands, because that can lead to a whole lot of unfairness, prejudicial behavior, and allows the association to be judge, jury, and executioner in these circumstances, and not to have regard to whatever defenses get raised, like, for example, look, there was nothing we could do about it. We tried all best intentions in the world, but it got stopped by counsel because counsel just aren't doing what they should be doing. You can't hold us liable. You can't take away our access. He did have another access to his residence. So the property was being built somewhere else. So it wasn't a question that he couldn't get in to his house, his residence, but the workers, for example, the contractors couldn't get in. And the court said that promotes self-help, and stated as follows: the applicant's biometric access and the contractor's access merely upon the respondent, that's a Homeowners Association, forming the opinion that he or she has breached the rules. And that's the important part: without first having recourse to a court of law in order to seek sanction to do so, amounts to self-help. Dispossessing a person against their will or without an order of court amounts to self-help. The same as the landlord changing the locks for a tenant to lock him out. This was akin to that, and said, you can't do that, you've got to follow due process. Not that the rule itself was invalid, which said you can do as you please, but you can do as you please subject to a court order. And that line of thinking appeared in another judgment I want to deal with, which is quite cited also quite a bit, of Niverkloof Private Game Reserve versus Hanekom. And in this instance, Mr. Hanekom or his family trust had fallen into arrears in relation to his levies and special levies. And the other rules of the association specifically said that, I'll read it to you, that when a member is in default of any payment obligation, being levies or special levies, or any other obligation, okay, which doesn't apply here, the defaulting member shall not be entitled to any of the privileges of membership, including but not limited to his right to access and or use of the reserve, there was a game reserve, or any of the common property. So they deactivated his access to the reserve and the common property. And he then applied to court to say that that rule was invalid, and it must be set aside. And the court said, no, there's nothing, although the rule could lend itself to self-help, that isn't in itself a basis to declare the rule invalid, and said that while the provisions of that clause I've just read to you are capable of implementation in a manner that is unconscionable, illegal, or immoral, the 10 of the provisions themselves are neutral in that they do not exclude, as an example, the appellant from approaching the courts to give effect thereto. So had they applied to court to say, we want an order compelling Mr. Hanekom to pay his levies, and pending payment of his levies, an order deactivating his access to the game reserve and the common property, the court in all likelihood would have granted it. And then they would have been entitled to do so. But at least there would have been judicial oversight into the implementation of the rule, as opposed to the homeowners association deciding for themselves there had been a breach in those circumstances and dispossessed the homeowner, and in this instance, Mr. Hanekom, as had appeared in the judgment I referred to earlier of Bill versus Waterfall Estate Homeowners Association, where they said it amounted to spoliation. So the rule was valid, but you just need to be careful when you implement it that you don't resort to self-help. Now, the next judgment I want to refer to, I will give Zelinda all these cases. So if anybody wants to read up on them a bit more, then you can do so. So I'm just sort of trying to do a bit of a whistle-stop tour through some of these cases and just touching on them, because in the hour I won't be able to give justice to them. The next judgment is one of Kingshaven Homeowners Association versus Buerta, a 2023 judgment of the Western Cape High Court, a Binns War judgment. I referred to this judgment when I did the webinar a few months ago in relation to the jurisdiction of CSOS and the appeal process from CSOS to the High Court. But in this instance, I want to rather turn to what the other important aspect of the case was about, which was the enforcement of the rules. Now, in this instance, the rules said, or what became the issue was the parking of the motor vehicles and the fact that Mr. Buerta parked his car everywhere. And that became a problem. And when I say everywhere, he was only entitled to park his car in his garages or in his driveway. But he parked either in the pavement and straddled part of the road, or he used the visitors' parking bay. And there were repeated breaches by him. The Homeowners Association complained to him, and he said, well, that's where he's parking. He had fridges and things in his garage, and he said, well, everybody does that. There's not enough space in his garage for his car. So he parked a little bit in the driveway, but he said the driveway is too short, and that's why his car straddles the road, and he would park in the road and in the visitors' parking bay. And he said, well, everybody does that, so you can't hold me to account. And the matter, the Homeowners Association referred it to CSOS to get an interdict to stop this practice, and CSOS correctly said they didn't have jurisdiction to grant interdicts, and the Homeowners Association then appealed to the High Court to say, well, they did have jurisdiction. Alternatively, they wanted an interdict to stop Mr. Buerta from parking and breaching the rules as he was doing. So the court agreed, and it was common cause when it got argued that CSOS didn't have jurisdiction to grant the interdict. But so the matter then centered on whether or not the Homeowners Association could interdict Mr. Buerta from breaching the rules, and specifically from parking essentially where he liked. He came to court, or part of his papers were, he showed photographs of cars parked here and there, and of cars parked in the visitors' parking bay. The court again, and he also said, well, you know, these rules are not enforced properly, and therefore the Homeowners Association has, as he put it, waived compliance with the rules because other owners parked, call it badly, or parked as they pleased, other owners, and the trustees had applied the rules in a discriminatory manner and they can't do so. Again, going back to the point I made earlier, when a homeowner says, but why me? What about him? That defense, which I'm sure you've all come across quite often. And the court then said that the rules, again, are a contract between the party. All the judgments all keep going back to this theme of a contract between the homeowners association and the owners, and it regulates the relationship between the owners themselves, and said that the Constitution and rules create a contractual relationship between the association of the members. The instruments, i.e. the rules, are intended to operate not only between the association and each subscribing member on a mutual basis, but they also constitute a pact between each subscribing member and the association for the benefit of all subscribing members. And that the object of the rules are directed at the common good of all homeowners and at regulating their conduct between themselves. By subscribing to the Constitution, each member accepts the benefits stipulated in his or her favor by the other subscribing members. One of these benefits is that there shall be rules of conduct to give substance to the objectives and rights promised and conferred by the Constitution, and other members will be required to comply with them, and any breaches thereof will be called to account. And the court then looked further at the Constitution and remarked that the Constitution gives the trustees to make rules of conduct, to enforce the rules, and unsurprisingly does not give them the power to waive compliance with the rules, and made the point one can waive a right but not a duty, and that the trustees were obliged to make rules and enforce the rules. Nothing gave them the right to waive the rules. The court then, besides setting out the basis that you can't waive the rules, also said that on the facts, the rules hadn't been waived in any event. There weren't enough. The fact that he took photos of cars in visitors' parking bays meant nothing, because it could well have been visitors in any event parking in that parking bay. And the court again made the comment about the fact that the rules hadn't, as he argued, hadn't been enforced strictly, made the point and said that I do think that Mr. Botha, as a party to a contractual framework established by the Constitution and the rules, he could not have reasonably perceived that any laxity in the enforcement constituted a waiver of the parking rules. A reasonable man in his position would have appreciated that an apparent abandonment by the trustees of the association's right to enforce the rules couldn't happen without the rules formally being changed by the majority of the members. So through that argument out, and then also in relation to the discriminatory manner in which the rules had apparently been enforced, the court held, and he said, well, it's a reciprocal obligation. The homeowners association must enforce the rules and we must apply, but if the association doesn't enforce the rules, then we don't owe a reciprocal duty to comply with the rules. And the court said that's nonsense, and said that the court held that the enforcement by the association of his parking rules was not subject to the principle of reciprocity, and that a failure by the homeowners association to enforce a breach of the rules against an owner does not preclude the homeowner from enforcing such breach against another owner. So that basically says you've got to comply. You can't say, well, what about him in the odd instance? But there is a case which I do, however, think I should bring to your attention, which sort of showed how it's not hard and fast. And in the matter of Reddy versus Cedar Lakes Homeowners Association, another Gauteng judgment, this homeowner, instead of doing green pinstripes, installed his garage with mirror exterior finishes. So I don't know how that would look, but in my mind's eye, that can't look very pretty with mirror garage doors.
It must help with parking though, right?
Sorry?
It must help with parking. You can see yourself approach.
Yeah. As you park, you can park pretty. If you crash, then, and I don't know, because you can see all around. You can check me back sort of scenario. So he had these mirror garage doors, and he then put them up, and then he apply. He didn't apply for permission before he put them up, but he applied after he put them up. And the Homeowners Association refused the request to install the garage doors and demanded that the doors be removed. And he then raised the point that there were other garages in this Homeowners Association which had the same finishes, and wanted to therefore know why he was being singled out when many other people had those type of garage door finishes. And the Homeowners Association didn't get back to him. So he then, sorry, maybe I should go back one point, that in the matter of, just to set the scene, in the Kingshaven matter with the parking bays, the court did make the point in saying that an irrational discriminatory system of enforcement might justify the basis to refuse an interdict. So although it found that the rules in this instance, you couldn't say, well, other cars had parked in the visitors' park, other owners had parked in the visitors' parking bay, or it straddled the curb or straddled the road, the court said that isn't a basis and you can't waive the rules, etc. And did make the point that if the rules are, if there's an irrational discriminatory system of enforcement, then that might be a basis not to order the homeowner to comply. And the Reddy versus Cedar Lakes Homeowners Association is an example where there was an irrational discriminatory system of enforcement at play in relation to these garage doors, because he could point out with photographs that there were many other houses in the area which had these same mirror finished garage doors. And the fact that they didn't even get back to him and say why they were allowed to have those doors, they didn't get back to him at all. And the court found that the adjudicator, that the CSOS adjudicator had failed to consider evidence presented by the trust of other garage door finishes with materials other than timber, as required by the rules, and in particular, like mirror garage door within their estate. The court held further that the adjudicator had failed to correctly consider the Homeowners Association had not responded and explained its decision to the trust when the trustees required, that's the trust, the family trust, inquired as to why other unique garage doors had been approved, but not the garage door on their property. So there's an example of if there's blatant inconsistency, and there's sometimes a thin line between the two, but you would have to go more than just saying, but what about Joe? You'd have to show that generally on their estate, it's pretty much a free-for-all, and you now are applying pretty much discriminatory practices against us. But just pointing out to one person, for example, there are cases where people have had dogs, but perhaps they were allowed, and there was a case, I haven't had time to deal with that case, where someone had a dog, but that was in terms of the old rules. And then new rules came in and new directors came in and said, from now on, we're enforcing these rules. And the owners weren't entitled to say, but what about Joe? He's got a dog. They said, well, that was the past. From now on, we slowly but surely, those dogs would sort of die out without trying to sound cold about it. But from now on going forward, no dogs allowed. And in those instances, couldn't say, yes, but what about the other dogs? That was Homeowners Association, which is governed, as I've been pointing out, by contract, in the rules. And then we've got the body corporate sectional title, which is obviously governed by the Act and the management rules. We're doing okay for time. 20. Okay, so
we're fine.
There is a matter which isn't law, but it does express the frustration of, I think, a lot of body corporates and homeowners for that matter, where there's just blatant disregard for the rules. And in this one matter, which goes back all the way to 2003, Judge Villa, who was still an acting judge then in the matter of body corporate Shaftesbury sectional title scheme versus Rippett's, the problem there in that particular sectional title scheme, or the owner was using his premises for drug dealing and prostitution, and he didn't pay his levies. And the body corporate applied to court one, for an interdict, and two, to eject the homeowner from the premises pending compliance with the court order, or at least in for the interdict being granted. And the court held as follows, and I think I've referred to this case because I think it captures the frustration of a lot of body corporates, and I said, as I mentioned, homeowners. And it said, this is what Judge Villa said: in my view, there is a pressing social need, put that in inverted commas, in South Africa to enable sectional title owners and their controlling bodies to enforce compliance with their conduct rules, and in so doing, if necessary, deprive the owner and or the occupier of the right to reside in or use of a unit in circumstances where there is a constant and deliberate contravention of the conduct rules, including non-payment of levies imposed. Then he goes on to say, I can find no authority for this court to grant an order for ejectment in the present circumstances, and then doesn't give it because there's no authority. But that sort of encapsulates the frustration that a lot of body corporates or homeowners have, that they've got these rules and you can fine people, and some people will pay the fine or they won't pay the fine. But if only we could get rid of those people. And for example, let's say there's a fishing club and someone doesn't behave well. Let's say they're drunk and disorderly. That person would be expelled from the club. So on that basis, an association whether it's a homeowners association or a fishing club, you should be entitled to expel that person. But obviously it brings in the whole thing of right to housing, the Constitution, and it's quite a far-reaching and draconian provision. And the court, in expressing its desire to do so, realizes it can't do so, and then simply granted the interdict to stop all the contravention of the rules. And if the homeowner continued to breach the rules, that would be contempt of court, and the person can then be either fined or, in severe circumstances, actually imprisoned for a breach of an interdict, because the interdict is a court order. So in this instance, the court said, okay, well, I can't eject them as much as I'd like to, but ordered that they refrain from breaching the rules, comply with the rules, no more prostitution, no more drinking, no more disorderly conduct. And if there was a breach, that would be contempt of court. The other judgment of a body corporate, and that's one that comes up quite a lot nowadays, all the time, in fact, relates to Airbnbs. And that's body corporate paddock sectional title scheme versus nickel. And in this instance, the homeowner had been, or the member had been using her unit for Airbnb, and there started to be a lot of complaints about the people coming and going, and I'm sure many managing agents here will have come across that problem, where there's a frustration of this influx of people coming in, coming and going, and there's no control, and the risk, security, etc. And in fact, in that judgment, I'll list what the court referred to were the security concerns that got raised. That the applicant at the body corporate was not aware at any given time who was in the unit. The body corporate couldn't validate the identity of all the tenants entering and coming and going into the complex. There was no verification system. Even where there are verification systems, it's, people bring guests and people come and go, and there was just no way to validate who was in the premises. By having access to the complex, the respondents' tenants also had full access to the common property, including the garden and the swimming pool. And by the nature of it, often people who are there just for the weekend can cause disruption and damage to common property, which means the other owners have to then pay for that. And the high number of coming and going not only poses a security risk, but jeopardizes the reputation of the scheme, as these short-term tenants do not always adhere to the conduct rules. There's disturbance, there's noise, and a whole lot of factors. So there were all these complaints in this particular body corporate, and eventually the body corporate imposed a rule that short-term letting was prohibited, and you could not rent for less than, I think it was 3 months or 6 months. you couldn't for less than that. But I think it was 3 months. If you look at the facts, well, 3 or 6 months, they said that's no longer allowed. The homeowner, or the unit owner, Mrs. Nicol, took issue with that on various grounds, and she said that that was unreasonable and she should be entitled to do what she likes with her unit. And the court again looked at the whole concept of communal living and said that in the context of communal living, the question that needs to be asked is whether the complaint by the other owners is objectively reasonable. In other words, is it fair to require the other owners to tolerate the intrusion? The answer will vary from scheme to scheme. What is acceptable in a sectional title scheme inhabited by mainly students may not be reasonable in a quiet residential estate such as the paddock. So it's important that this case be seen in the context of that particular sectional title scheme where there were 10 owners. And the court was at sort of upfront distinguished that if it's a unit which is a lot of students and people come and go, then this case would not necessarily apply in those instances. And the court then, in looking at the communal scheme or the nature of a communal scheme, said that it's important to highlight the freedom of body corporates to regulate themselves. Owners in sectional title schemes buy into these schemes, knowing that there are rules and knowing that the rules may be changed with the requisite majority. The body corporate's freedom to regulate itself should not be overlooked. That is the very nature of a scheme, which has its own checks and balances in place in order to ensure that the majority are in favor of the rules and which are in the interests of and for the benefit of all the members, and which rules have in any event have to obtain the approval of CSOS. The respondent, that was Mrs. Nicol in this instance, was well aware that when she purchased the unit, she would be subject to conduct rules with future amendments thereto. The majority voted in favor of the new conduct rule, which rules ought to be respected and preserved. And lastly, went on to say that these conduct rules relating to the fact that you couldn't lease your premises for less than 3 months was for the benefit of all occupants and residents in the sectional title scheme who reside within close proximity to one another. It is therefore essential that the rules be complied with so as to ensure that the rights of all occupants and residents are respected and so that they can live in harmony with one another. The respondent, that's Mrs. Nicol, cannot and should not be allowed to break these rules. She then argued in addition that, so she was immediately, sorry, she also argued that, well, it's unconstitutional, it deprives my constitutional rights to property, and she referred to Section 25 of the Constitution, which says no one may be deprived of property except in terms of a law of general application. No law may permit arbitrary deprivation of property. And she said that's the arbitrary deprivation of my rights to my property. I can't lease it to who I want to. You're preventing me from paying off my bond, which I need the funds for, and it's unconstitutional. And the court also rejected that argument and said it wasn't a significant interference with her right. She could still lease her unit, just not for 3 months, was only the length, but wasn't precluded from leasing it for any longer period. The rules didn't require to know who you're renting to. There was no invasion into rights other than the limit of 3 months. And the court said that isn't a significant deprivation of her rights and found therefore that the rule was not unconstitutional. I think we've still got a bit of time, 10 minutes or 15 minutes. I'm not sure exactly when we started, but to really touch on the levies and the obligation to pay levies. So to wrap up on the rules, both in the body corporate and in the homeowners, the courts have clearly said in no uncertain terms, rules are there to be complied with. And if you don't comply with the rules, the courts will grant interdicts to enforce the rules and fines that get imposed, as in Edgecombe matter where fines were imposed was lawful, but you can't take the law into your own hands in stopping people gaining access. You'd have to get a court order. But say for that, the courts will interdict an owner who breaches the rules, like we had in Kingshaven, where he was parking wherever he liked, can order people to remove or to repaint take away the paint, the pinstriped lime greens. That must have been awful to look at. To remove it and repaint. So the courts will also take a wide interpretation and applying the Indomeni judgment and enforcing and interpreting the rules and in enforcing the rules. So owners who try to hide behind the pure grammar of the words probably will not be successful, because the court will give an expansive interpretation to the rules. I'm just going to touch on levies now, because that was part of the blurb of what I was going to talk about, and whether a homeowner can withhold payment of his levies. And the short answer is no. The courts have, in many instances, stated that either the rules don't allow it in a homeowners association or in a body corporate, you can't. And if you have a grievance, then you must follow the remedies in terms of the act, which is, I'll get to just now, but you can't just take the law into your own hands and not pay your levies. So the few cases I'll touch on in the short time we've got is, the first one is Kingsmead Office Homeowners Association versus Shari Investments, which is a KwaZulu-Natal judgment. And in that case, the homeowner didn't want to pay his levies, and he said he hadn't been, it was a commercial property, it wasn't residential. And he said, well, he's got no benefit from being part of the association. The plaintiff, the homeowners association, was meant to have erected a wall around his property, which hadn't happened. And the plaintiff, the homeowners association, had neglected to maintain the common property. And the court said that there was no obligation on the part of the homeowners association to do what he said he was meant to do. And even if there was, an owner was contractually to pay his levies, and made the point that rather than seeking relief in some other form, he simply refused to pay the levies. And the court said that's not acceptable and ordered him to pay the levies. In terms of that's in the homeowners association. In the body corporate, that's all dealt with in terms of Section 3 of the Act, which is pretty much the same as the old Sectional Title Act. There's a different wording. In the old Act, it used to refer to the fact that once the trustees decide on the levies, it's due and payable. In the current Act, it says that levies accrue from that date onwards. And in a matter of body corporate of Kleber, the court determined that it basically means one and the same thing, and was just bad drafting, that there was a change of wording from the old Act of due and payable to now accrues, but it meant the same thing. So in terms of the Sectional Title Act, the Act and the rules or the regulations 25 deals with the payment of levies and the enforcement of levies. And in the matter of body corporate of Fish Eagle versus Group 12 Investments, which is a 2003 judgment dealing obviously with the old Act. In this instance, the homeowner didn't pay his levies, and the defense he raised was that he had incurred certain expenses, repair costs, and he was offsetting that, and that the body corporate had been mismanaged and he wasn't therefore paying, and that resulted in a special levy, and he's not paying that. And he said that it had been decided at a trustees meeting that they were going to cancel the litigation and were rather going to try to do a deal with him, negotiate with him. And the court rejected all those arguments and said that you've got to enforce your rights in terms of the Act. You can't just set off. In any event, a repair cost is damages, which isn't an amount that can be set off against monies owing. Plus said you've got to follow your remedies in the Act, and in this instance was either to apply to court for an interdict to get the body corporate to do what you said it wasn't doing, or to appoint an administrator to run the affairs if you say it's been mismanaged, or to convene a special general meeting and remove the trustees who you say are not doing a good job or mismanaging, but you can't withhold payment of your levies. In the terms of the current act, you can refer a dispute to CSOS in terms of section 39, subsection 1C, in relation to the levies, which you say are excessive or unreasonable, but you can't just not pay your levies. You've got to follow your remedies in the act. The argument that in this instance, similar to the Homeowners Association scenario, where it was argued, yes, but you had agreed that you wouldn't, there was this agreement, a resolution that you weren't going to proceed with the court action. The court rejected that and again said, in terms of the act, the trustees are required to enforce the rules. There's no provision in the act which allows them not to enforce the rules or to waive the rules. And if they did so, they were acting ultra vires, contrary to the act, which they can't do. So an argument that they decided not to take steps against me is invalid. The trustees can't do something like that. A similar, I'm not going to deal with this case, we're going to run out of time. Dolphin Ridge Body Corporate versus Express Model Trading, which was a Western Cape High Court judgment. Also, the owner didn't pay his levies. He said in that case, the body corporate had not carried out its duties and responsibilities in terms of the act. And the court said that there was nothing in the act or section 37, which relates to the levies in terms of the old act, which creates the impression that levies can be withheld on the basis that the trustees of a sectional title scheme had failed to discharge their duties. And then the last case I'm going to touch on in the last 2-3 minutes I've got is Zikalala versus Body Corporate Selma, 2022 judgment, where the court was in the process of executing the immovable property of the homeowner, and prior to proceeding with an application to attach his immovable property, the attorneys and the trustees had agreed with this homeowner that they would accept a certain amount in full and final settlement of a claim that they were instituting at the time, which was, call it half of what was owing, and there was still a lot more owing, which wasn't the subject of court litigation. And they did this deal, and afterwards they realized, oops, we couldn't have done this deal because there was a lot more money actually owing. He took the point, well, you've done the deal, and I don't owe any more than what we've agreed on in full and final settlement. That then became the subject matter of the dispute that went to the High Court, and the court found, similar to the judgment I've just dealt with, that the trustees did not have the authority to waive compliance with the rules or to settle on any amount less than what was required of the homeowner to pay. And just briefly, the court said, when an owner fails in the obligation to pay amounts, the body corporate is empowered to take action to recover such amounts, including interest and costs. I'm unable to find any power in the management rules or the act that permits the body corporate to compromise its obligation to collect levies or contributions, and therefore were not empowered to even enter into a settlement agreement, and said that the fact that the attorneys did so and the trustees agreed was irrelevant. They didn't have the authority to do so, and he should have known that they didn't have the right to waive his obligations in terms of the act, and the court regarded that agreement as invalid, and the owner was then required to pay. So that in a nutshell is the obligation of an owner to pay the levies, that you can't use excuses that the levies are excessive or unreasonable, or I don't use the lift because I'm on the ground floor. If those are your levies, that is what you're required to pay. If you have a problem, you must follow your remedies in the act, but you can't apply self-help and just deduct what you feel is reasonable. And if there's a dispute about the reasonableness, mentioned what the other judgments had said about your remedies, plus now in this instance, or now since the act, you can refer a dispute to CSOS. And that's about it, Celinda.
Fantastic. Thank you so much, Antony. I know that we have run over, so for those of you that aren't able to stick around for a couple more minutes, you are more than welcome to jump off. Thank you so much for giving us of your valuable time this morning. There are a couple of questions in the chat, and I wouldn't mind if we can just deal with one or two of them. Antony, do you have another couple of minutes to give us?
Yeah, I've got time. I'll try to get to the bathroom and get something from my throat.
Of
I'm quite
course, of course.
thirsty.
No
I'll be a second.
problem. No problem at
I'll
all.
be a second.
No problem. So while you
Okay.
are off for a second, I just want to actually raise one or two of these questions with those of attendees that are still online with us. And I thought that quite an interesting one was the issue about the valid driver's license. In other words, if you've ever gone to a homeowners association and as a visitor and the access controller has not allowed you to enter because you don't have a valid driver's license. I was actually at the airport last week, and the gentleman checking me in reminded me that mine is expiring at the end of this month. So that's definitely a good thing to keep an eye on. And then another important question that was raised is, what about historic illegal structures? So in other words, if at one point in time the trustees or directors see that there are quite a few illegal alterations or renovations or structures, what can you do there? Should you allow it to remain as is, or should you remove it? And then the question about suspending membership privileges and perhaps frustrating access, in other words, letting an owner sign in, whether or not that's also classified as spoliation. If there's any other big questions that you've got, you're more than welcome to post it on the chat. Thank you so much for your comments. Is there anything that anybody would like to raise online while we have a minute or two until Antony joins us again? I'm just going to change my view that I can see you. You're more than welcome to raise your hand or unmute yourself. Nicole, I know that I popped you and Rosine a couple of questions or a couple of comments about a few of the body corporate CSOS matters that we've been involved in. That would be quite an interesting one to have a discussion with Antony about. I'm going to have to remember what those body corporates' name is. I see there's a comment on the group about how do we get the webinar. Just a reminder that the webinar recording is on our website. We have posted the link in the chat. Carl, if you could perhaps just post that link again of all the recorded webinars, our previous ones included. Now, my point of view when it comes to the access control of a homeowners association is that provided the constitution or the memorandum of incorporation allows for any form of requirement of signing in or having a valid driver's license, it would be valid. I see that Jolene is online. Perhaps she would like to give us her view from some of the matters that she dealt with at CSOS as to whether or not this is something that the CSOS would allow. I know it's very different in body corporates to homeowners associations. And then the historically legal structures one is always a complicated one, because if there is a widespread non-adherence throughout the estate, it would be very difficult to give an order that these structures have to be removed and the areas reinstated. Antony, just a quick one. The questions that I wanted to raise on behalf of one or two of the members was, would a homeowners association be able to deny or limit entry in the event that somebody does not have a valid driver's license?
You mean someone from a visitor?
A visitor, yeah. A contractor, visitor, guest.
Yeah, yes. And I've got some friends who live in these estates, and it is just so frustrating. In fact, my license just expired, and they wouldn't allow me in because they said the car's not roadworthy. And I made a whole big fuss, and I looked into it, and because they gave some convoluted argument, but they can check that the person is who they are. So your verification purposes can see that you are, who they say you are. Whether or not they can go as far to say, well, it's not a valid driver's license, the argument is that they must protect the interest of the community. And if someone is involved in an accident who's not licensed, that person will not necessarily be covered by the insurance. So that's how that argument goes, that they can dictate who comes in, not only verifying who that person is. In other words, it is Antony Arvan, but that Antony Arvan has a valid driver's license. So and his car is roadworthy, because as I said, if he's involved in an accident and he has insurance, they don't want the insurance to be repudiated, and therefore the homeowner isn't covered because my insurance repudiates, because I'm not licensed.
Sure. So Nicole and Raz, we've been giving the correct advice. Fantastic. Antony's confirmed it. The next one is if there is any historic illegal structure. So in other words, in a homeowners association, when an owner, or even a body corporate, when an owner went ahead and did alterations or renovations without getting the relevant trustee, director, or member approval, what is your advice regarding how the homeowners association or body corporate should address it, either to have it remedied, alternatively to have the area reinstated, or the illegal structure removed?
When illegal, is it illegal in the sense of there's no municipal approval either, or is it lacking trustee approval?
Well, maybe there's two different answers, so feel free to deal with both of those scenarios.
Well, firstly, besides the imposition of fines, because I'm sure there'll be fines, we're dealing purely with the structure itself. Yeah, and let's assume well, I suppose it won't necessarily even make a difference insofar as the rights of the homeowners, the homeowners association is concerned. If the structure doesn't have approval, the homeowners association can ask the person to comply. So if the structure would comply with everything, but just doesn't have the approval, can ask for them to submit the plan so they can be approved. They can stop building work in the meantime, obviously. So if the homeowner is starting to build and doesn't have the approval, they can apply to court for an interdict. If, however, it is already done, then, and would not have been approved had approval been required, then they can apply, then they can ask him to remove the illegal structure. People, let's say, for example, they put ones I've dealt with, the satellite dishes in the wrong place, or the braai room has now got this huge chimney which are not allowed, or whatever. You can ask for it to be removed, and if the person doesn't remove it, can then apply to court for an interdict to compel the person to remove the illegal structure, similar to the paint, where the court ordered the green stripe lime paint to be removed and painted in the color that we say. The court will grant what's called a mandamus, order compelling someone to do something. Normally an interdict is, and in our case, the scenario I gave is where the building is starting to go up, you can get your more sort of commonplace interdict, which is the negative interdict, to say, stop doing that, stop the building work. But then the positive interdict, where you compel someone to do something, which is to remove whatever you've done. And if you don't, they would be entitled to apply to court, the High Court, to get an order compelling not to CSOS, because as we know, CSOS can't grant interdicts, to apply to the High Court for an interdict to compel the homeowner to remove the illegal structure. Plus, the reason why I mentioned the municipality, if it doesn't have municipal authority, the municipality in turn, on top of that, can take issue with it in terms of the national building regulations, because they don't have approved building plans. But the fact that you have approved building plans doesn't take away the homeowners association's rights to enforce compliance with its own rules.
Fantastic, fantastic. I think I'd like to give you an opportunity, Antony, just to give us a little bit of a spiel about how you're involved in arbitrations and heritage matters, just out of interest for any of our attendees or anybody that listens to the recording, should they wish to reach out to you. You know, what are your areas of interest? And then, of course, a wider, your firm and your colleague, I know Etienne is close to you. What do you guys enjoy doing, and what can our listeners contact you about?
Sure. Thank you. That's very nice of you. Well, I myself do dispute resolution, as the introduction earlier, which was pretty spot on, mainly property related disputes, but not solely that. So I will deal with other disputes. I'll draft agreements, but that's not my preferred is getting into the trenches and resolving disputes. And that generally is the form of acting either for a homeowners association, body corporate, or obviously an owner in certain or many instances, but also construction law, where a house has got a problem, or building goes up and there's a problem with can be a lot of reasons, and or the house has problems, structural problems, or is it architectural problems? So those sort of disputes are any property related disputes we will deal with either through the courts, And a lot of agreements require the dispute to be dealt with through arbitration. And arbitration is something which I particularly promote because it's far quicker, not necessarily cheaper, but can be cheaper because the process is a lot more protracted, but you get to choose who your arbitrator will be. And the decision of the arbitrator is binding on the parties and can be made in order of court and has the same effect as a court order. But it's far more flexible. I had an arbitration at the office here last week. So we just have in our boardroom, we get an arbitrator gets appointed. We've got a nice big boardroom. So you don't necessarily have to find premises through these bodies who deal with arbitrations like AFSA. I'm sure you've all come across AFSA, or the Association of Arbitrators, which deals with Association of Arbitrators deals mainly with building disputes. And the AFSA deal with a lot of commercial disputes.
Oopsie. Have I lost internet connection, or is it on Antony's side? Antony's side. Oh dear. Okay. Ladies and gents, are there any comments or questions that you would like to make online? Otherwise, I think sorry, Antony, we lost you for a second. Would you like to continue?
Yeah, so just one other thing. The heritage is something which I particularly like because it's interesting, and that in terms of the Act, the National Resources Heritage Act says that any building, well, it says a lot of things, but the one that I come across quite a bit is the provision which says that any alterations to a building older than 60 years needs to get approval from Heritage Western Cape. So if that means you want to change the building, knock the building down, you need approval of Heritage Western Cape. So a lot of developers or developments can come unstuck where they buy property. There's an old Gedonk house on the property, want to knock it down and build something there, a big building. And I've been involved with a lot of disputes in Sea Point, where it's an old house, they want to build a huge block, and some have gone up, fortunately, but would have stopped had we not then applied all the way to the High Court, where Heritage Western Cape says, no, there are heritage resources in the area, either that building itself or next door, there's an old church, or there's this or that, and a new building will impact on either you can't knock this building down, or if you build something up in this place, it would detract from the heritage resource next door, like an old church. In Sea Point, there's an old fire station where developments were almost stopped. And then you get into the whole history of the buildings, the architecture from those times. And I've got a love for history. So a blend of history and law, which is great. So I find that quite interesting. So yeah, so any of those sort of disputes are also things which we deal with. And then our office obviously deals with conveyancing, commercial disputes or commercial agreements, etc. Etienne sort of pretty much does what I do. And yeah, we do a host of things, but anything which, yeah, a wide range of stuff. But those are my specialities. Thank you, Zelinda.
Fantastic, fantastic. Etienne, you're a very, very lucky young gentleman to be working with Antony. I know Nicole, Null, and I very often fangirl over your correspondence with us and your wide range of knowledge. So we really enjoy having you on our webinars. It's been a really great webinar. Thank you so much. We've seen very positive comments in the chat. Just a reminder, everybody, that the recording of the webinar will be shared on our website along with Antony and Etienne's details, as well as all the case law that Antony referred to. I have also shared his email address, so please feel free to reach out to him to get some more information about the services that him and his team offers. Thank you so much, Antony. Thank you, Etienne, for your time. I know that a lot of preparation went into it, and I know that you're a very, very busy man. So we thank you so much for joining us today. And on that note, ladies and gents, please have a lovely month further, and we'll catch you next month, hopefully both physically and online. But until then, if you have any questions, if you'd like to know what more we can assist you with, please do reach out and pop us a mail or check out our website. And we look forward to hearing from each and every one of you. Thank you so much. Have a good day further. Bye-bye, everyone.
Thanks, Zelinda. Cheers.
Bye.
Bye.